Oh, you're still muted. Hold on.
How about now? Can you hear me?
Now you're good. Thank you.
Great. Thanks so much. Thanks everybody for attending this press avail. So in regard to the request that we received in respect to the Ottawa County Board of Commissioners, I want to talk a little bit about what we did in regard to our investigation. The Department of Attorney General executed a comprehensive review, and that included the review of dozens of citizen letters and emails, which is the most actually my administration has ever received in connection with a single public body. We reviewed each board meeting since January, which of course had been very well attended by the public. Of the over 70 public comments at the January 24th, 2023 meeting, a substantial portion were directed at the board's lack of transparency, and they questioned the board's compliance with county rules and policies. And here's what we found. The actions of some of the members of the Ottawa County Board of Commission clearly demonstrate a violation of the spirit of the Open Meetings Act and a blatant violation of public trust and the tenets of government transparency. Now, it's apparent that certain incoming members of the board met prior to the January 3rd, 2023 meeting to discuss the motto change, termination of the public health director, corporation counsel, elimination of the DEI program, and hiring of a new legal counsel. And this was all done outside of the public view and to execute their will without any public interference. However, there appears to be no actionable violation of the Open Meetings Act or of other relevant laws at this time, which is why what I'm doing is this. I am proposing amendments that would strengthen the Open Meetings Act. The OMA is intended to protect the right of all Michigan residents to know what goes on in government by shedding light on the official acts of public bodies and enhancing responsible decision-making, and thus promoting government accountability. But it's not without fault. So these changes would firstly require a public body to include a meeting agenda along with a notice for the public meeting at least 48 hours in advance of the holding of the meeting. And it would limit the ability to modify that agenda during a meeting, except in exigent circumstances. And secondly, it would amend the definition of the term public official to include a person who has been elected or appointed to public office, even if they have not yet actually taken their oath of office. Current OMA does not require an agenda. It does not define public official to include successful candidates following the election up until they take the official oath of office. So I guess the question really is, where do we go from here? Well, residents may have rights and remedies under the OMA and in the Michigan Constitution, such as a citizen has the right to commence a lawsuit against a public body under OMA to challenge the validity of a decision of that public body made in violation of the act. And I know we've seen at least one of those lawsuits. A citizen may also obtain a court order compelling a public body's compliance with the act or enjoining further
Lansing, Trevor Gonzalez, 13 on your side.
Trevor, thank you.
A citizen who succeeds in a lawsuit filed under the Open Meetings Act may actually recover court costs and actual attorney fees. Citizens may contact the audit section of the Community Engagement and Finance Division of the Michigan Department of Treasury for concerns they have about the expenditure of municipal funds. And the Treasury Department can be contacted at 517-335-7469, or you could send a letter to 430 West Allegan Street, Lansing, Michigan, 48922. And the state treasurer can also refer the results of any audits to the Department of Attorney General for review as to possible criminal prosecution or the filing of a civil lawsuit. The Michigan Election Code provides for the recall of elected officials, including county commissioners, for their conduct during their current term of office through a recall petition process. And for elected officials with 2-year terms, a recall petition can begin after an officer has held their position for 6 months, but cannot be filed in the final 6 months of the official's term. And for more information on that, you can go to MCL 168.951. There are criminal penalties for OMA violations, as many people might know. A public official who intentionally violates the OMA may be found guilty of a misdemeanor and may be personally liable for actual and exemplary damages of not more than $500 for a single meeting. And there's also a criminal remedy. A public official who intentionally violates this act is guilty of a misdemeanor, and that's punishable by a fine of not more than $1,000. A public official who's convicted of intentionally violating provision of this act for a second time within the same term can be guilty of a misdemeanor and be fined up to $2,000 in the same 1-year potential sentence. Now, why does this matter, right? Why is all of this important? Well, full participation in the democratic process is good governance, right? And elected officials across the state, we may come from different regions and different backgrounds and different political beliefs, but we really should seek to serve the greater good of the residents of this state, no matter who we are. And we should seek to actively engage the public in the work of the government to build public trust through accountability and to improve our effectiveness through public participation in our decision making. This is consistent with the underpinnings of the Michigan Constitution, which many of you know actually says all political power is inherent in the people, and government is instituted for their equal benefit, security, and protection. So the notion of government transparency is just part of our national story. And so it's important that the power that government officials have not be abused. And we can also look, of course, at the co-equal transparency statute, which is FOIA, right? The Freedom of Information Act. And at its reflective core, its purpose is to provide citizens with full and complete information regarding the affairs of government and the official acts of those who represent the people as public officials and public employees. So they may fully participate in the democratic process. So, another thing that we're going to be doing is making recommendations to the legislature about changes in FOIA that we think are important. As many of you know, some of the individuals who are in the legislature right now, and I'd say notably Senator Moss and Senator McBroom, have been really vocal about indicating that they want to make changes to FOIA as well. So, one of the things that we are, officially, I guess, recommending to the Ottawa commissioners is, not only does my office have resources on FOIA and OMA on our website for any local elected officials to help them better understand the laws, but the Michigan Association of Counties also has resources for new and for inexperienced county commissioners to ensure that they're the best public servants that they can be. So, those are essentially the findings that we have made in regard to this investigation. It's the first such investigation that we've done since I've been in office, and in talking to some of my staffers who are on, and they're going to be available to answer some of your questions if there are things I can't answer. But I have Tom Quasarano on, who handles our FOIA and OMA related matters, and also the head of my state operations division, Jessica McGivney. But the thing that's interesting about Tom is that he's been in the office so long that he was there when these laws first took effect. And you'll have to correct me on this if I'm wrong, Tom, but I think this is the first time that the office has really undertaken this kind of an investigation into potential OMA violations. And so really what we learned is that OMA needs to be strengthened. There's no question about it. It needs more teeth and it needs more specificity so that the law can be properly enforced, and so that the people of the state know that their government officials are acting with appropriate transparency. So with that, I think that there are probably some questions that some of you have, and we'd be happy to take your questions as it pertains to this topic.
We not have any questions?
Yeah, Michael Kranz from the Grand Rapids Press here. Can you hear me?
We can hear you.
All right, perfect. So what's next for the, the new changes that you're proposing to OMA? I mean, does that go before the state legislature, or does that entail you working with them to create a bill here, or how does that happen? What happens next?
So I have spoken to both Senator Jeremy Moss, who oversees their elections and ethics committee, as well as Aaron Burns in the House, who has a similar committee there. And I've talked to both of them about some of these issues. And what I've suggested is that we do some work together in terms of us making specific suggestions and also working together to help format some of those and to incorporate them into law. And of course, my department would be very happy to testify in support of those changes. So I think if you ask either Representative Burns or Senator Moss, they may have a lot to say about this. And I think that there is great interest in making these changes. And I honestly think at long last, there is the political will to get it done. But I would say this about Ottawa County and the Board of Commissioners there. I think this is the best possible example of why these updates are so badly needed, because when you're taking a deep dive, I mean, it's a serious thing to file a criminal charge against sitting county commissioners. And of course, if you're going to do something like that, you better really know what you're talking about and have good laws that you're working with. And what we found to be the case here is just simply, OMA did not provide for criminal prosecution or for us to file a civil action in this matter, despite the fact that I think we can all agree that there were some pretty egregious actions that they took that certainly violate the spirit of government transparency.
Can you, sorry, Susan Samples, Wood TV8, can you enumerate those egregious actions and which are the most disturbing to you?
Well, there's a long list of them. Tom or Jessica, do you want to go through the specifics of the various items that we looked at?
Yeah, one of the, this is Tom Quasarano. One of the issues was whether elected public officials, though not yet sworn in to take their seats, in this case on the County Board of Commissioners, can legally meet in advance of a first meeting and essentially work through whatever issues, decisions would need to be made in the presence of the public. But if this were a different public body already having taken their seats, have been sworn in already, a different factual situation, that behavior, that conduct would be considered an illegal closed session of that hypothetical public body because they're making decisions and they're performing or conducting deliberations not in the presence of the public. The difference here is that the members had not been sworn in, taking their oaths of office. And so this meeting, as the Attorney General indicates, the spirit certainly of the OMA was not complied with, was not honored, and therefore having legislation that would take that factual situation and remedy it by indicating that even in that factual situation, meeting ahead of time would be a violation of the act. So that was a main one. Go ahead, Attorney General.
Well, I was going to say, yeah. So in essence, I would say that, this is based on a technicality of the law is why there cannot be an action that is pursued, and that the technicality that Tom just spoke of. But Tom, do you want to review, because there were a number of acts specifically that were taken. I thought that I had reviewed them, but perhaps not, that were taken during, especially that first meeting, when it seemed as though there was some immediacy to it. And it was clear that those decisions were not made during the course of the meeting, of course, with full deliberation before the public, but were made in private and in secret between some of those board members, but I thought we had a list of them, right?
Yeah, yes, there is. And when you look at the letter that was sent to the board, it does pick up on where the citizenry, for the most part, were raising these concerns. So, for example, decisions were made to revise or change the motto, M-O-T-T-O, the motto of the board. Doesn't seem like a major decision to be made, but it was a decision, and that was made in advance of the first meeting, as was the decision to change attorneys, the corporation counsel, from one firm to another. The one that is now, we understand, in litigation in the circuit court is to terminate the services of the current health director and the replacement with a person of another person that they would decide to put in that position. Again, done in advance of this first meeting, and to eliminate the diversity, equity, inclusion part of the county business. Again, this is decisions that are made by elected officials, but they are to be made, deliberated on, they're decided upon at a meeting open to the public, where the public can comment on it and be fully aware of what decisions are being made on whose behalf, on their behalf. So again, in the letter that was addressed to the board, these were pointed out one by one in good detail, so that there's no confusion as to what it was that the public in Ottawa County were concerned about. Enough the right to the Attorney General.
Yeah, and let me follow up on that with something, and thanks for that, Tom. You know, obviously, the way in which this board went about making those decisions, I mean, if it's not illegal because of a technicality, certainly I think many of us find it to be nefarious in nature and unethical. However, let me say this. I think what we've learned also from some of the actions of the Ottawa County Board of Commissioners is that it's just this: elections have consequences. And I will say that many of the things that that board did, they ran on that platform. And I don't know if people in Ottawa County, either they approved of those measures or the policies that that these members of Ottawa Impact have, you know, made part of their platform. Either they approved of it or they weren't paying attention. So it's really one of those things. So I think that this also is a message to us. We really have to pay attention to our county boards and to our local boards. And I will say, and as many of you know who are on right now, you know, we had some real issues with the case that was brought by Ottawa County that interfered with our opioid settlement and caused, you know, what I think is a significant delay in the distribution of our funding. So, and as I've said, like, you know, what happens in Ottawa County doesn't just stay in Ottawa County. It affected the rest of the state as well. So it's very important, you know, who we have on our county boards. But that, with that said, you know, it's important that people pay attention. Obviously, if people feel as though these, you know, particular members of the board that engaged in these acts, either they don't represent them well, or they are sufficiently upset about the way in which some of these decisions were made. Obviously, there is this provision in the law that after 6 months allows for the, you know, recall process to begin and for signatures to be collected. But that being said, I think this is a lesson to us all. If people are upset about some of the actions of this board, we really have to pay attention to these races.
Hi, this is Dustin Dwyer from Michigan Radio. I put this question in chat, but I understand the problem you're describing, but I'm having difficulty sort of thinking of other examples where the state has the authority to regulate the speech or the ability to meet of what are, you know, people who are still private citizens. I mean, obviously, we've heard from lots of residents about the problem here, but these people hadn't taken an oath. Can the state really regulate who private citizens can meet with if they haven't taken that oath yet?
Well, Dustin, I think that's exactly what our point is, right? That's why we are saying that we cannot take action, because they were not public officials at this point. They had not taken their oaths of office. And that is the reason why our department simply has found that we cannot take action. But I will tell you, in terms of if you're referring to a way to amend the law and that would have allowed us to take action, I guess it would be the law imposing some sort of responsibility for people once they are in a position to become public officials because they have been elected. And that would be a potential way, obviously, to hold people accountable for these kinds of acts. Whether or not that's good law or good policy, that can be debated by the legislature. I understand what you're saying in terms of there being pros and cons if it's prior to you actually taking the oath of office. But I think if people know when they run and are seeking to be elected, that as soon as they become elected, there are going to be certain responsibilities they have. And one of those responsibilities is not to use your position as someone who's coming into office to avoid OMA or FOIA. I mean, I don't know that that's too much of a burden to put on people when they've already, made the effort to run for these offices and to ask for people's votes, and people have voted for them.
If I can ask one quick follow-up sort of on a different topic. You talked a bit about FOIA, but as the Attorney General, you also have authority to subpoena. Were you able to get any emails, or did you seek any emails or communication between these individuals in investigating this?
Yeah, I think Tom and Jessica, I'll let you answer questions in terms of what process we undertook for the review.
Well, I would think that Mr. Dwyer directed the question in the manner that you had responded to, that these individuals at that one point in time were private citizens. They had not taken the oaths of office. There is a freedom of speech as to what they may or may not, as citizens of Ottawa County, see as important issues. But it goes beyond that. They were taking that private discussion, that First Amendment protected discussion in place, and bringing it to a meeting, and in a way that the public, I believe, in reading the public's letters, readily saw were deliberations and decisions that had been previously made. Again, when you have a vote that goes immediately to an issue without a lot of discussion or deliberation in the presence of the citizens in attending the meeting, it doesn't take a lot to imagine that, well, where did this come from? These they come out of thin air. And for example, there was an addition made to the agenda to discuss the health officer position. And that went immediately to, I believe, and I could be wrong and I'll stand corrected, a vote on it. But that's the issue. We're not saying that citizens of any color or stripe cannot practice their First Amendment rights, but this was different. This was citizens who were already elected, yet not taking their oaths of office, and then taking what occurred at that private meeting and then bringing it into a public meeting and then moving immediately into decisions that affected the rights of the public. And
yeah,
so,
and let me just say this too. We have cases all the time that involve, speech between private individuals that rises to the level of criminal conduct. We have conspiracy cases that we charge for all kinds of different crimes. And certainly, we know that threats are not protected by the First Amendment. There are a lot of circumstances where you can have conversations between private persons, but it still violates the law. If the law was changed in this manner, it wouldn't be the only time that occurred. Sorry, Tom, go ahead.
Okay, I'm gonna go ahead.
All right, I didn't know if Tom was finished with the answer to that question, but go ahead, Marisa.
Thank you. Marisa Oberle with Fox 17. I know you said that you guys reviewed the meetings that had happened since January, but can you talk a little bit more? Did you guys actually speak to any of the members who made these decisions? I guess how else did you investigate? And if, did you make requests to speak to these members? Did you request any, text messages, emails with them? Can you speak a little bit more to that?
Tom, Jessica?
Yes, well, again, we reviewed videos of every meeting held, not just by the board, but by standing committees. And so it's one of those situations where the popular expression is that the evidence spoke for itself. In that if any board commissioner member wanted to address what they were aware of was happening with the AG's office inquiry into this, certainly their comments would have been welcomed, and they could have contacted us if they thought there was information to add to it. But in reviewing the board meeting videos, we found that gave us ample basis to determine that citizen complaints were not vacuous. They were not unsubstantiated. So to answer your question, no, we didn't do interviews as such, but we did review the videos, and more than several of us watched the same videos to come to the same conclusions. I don't know. I hope that answered the question.
Yep. Thank you.
Okay, I think we have time for one more question. Okay, great. Well, thank you everyone for joining us today. Feel free to reach out to agpress@michigan.gov if you have any future questions, and we appreciate your time today. Thank you.
Thanks, everyone.
The recording has stopped.